Hey, everybody. Welcome to the Bold Inventor Show. I'm your host, JD Hoovener, with co-host Matt Colseth. Matt, good to see you. Yo, yo.
Good to see you too.
All right. We've both been busy doing outside projects. We were just chatting before, so it's a good time to do that. It's not too hot.
Yep.
Feeling good. There's actually a little sprinkle of rain out there for me today.
Best time to grow grass. It's in the fall.
In the fall, yep. Well, I'm hoping to plant some trees too.
Good.
Up here, which is great. So, for those that are new to the show, I'm a patent attorney and own Bold Patents law firm. And Matt here has been with me for several years, better part of a decade, I think we could say.
Something like that. Yeah.
Yeah, as our go-to trademark attorney and my co-host here. So while we are attorneys, we're not going to be talking anything confidential or legal. We'll just be talking fun legal topics and sharing legal information. If you have any questions and you want to come on, we're here at 12 o'clock. That's Pacific time every Wednesday. So come on, join us live if you missed us. We're here every Wednesday. This show today, we have a cool guest. He's a youth inventor. I think he said he's 12 years old. Is that what he said, Matt?
Yep.
Yeah. Yep. So Howell Jian is going to be coming on in just a few minutes. We'll answer a couple of our questions and then bring Howell on. His invention is very, very cool, intriguing, and I think is in the medical space. For vision. So it's a VR sort of using the Google cardboard. It's a piece, and there's a VR headset tackling glaucoma. So we're going to get to hear how he came up with that and show it off, which will be really fun. What else, Matt? We got a government shutdown, I guess, today. Does that mean the USPTO just everybody goes home? How does that work?
I don't know. I haven't looked into that yet. I mean, and then any other government shutdown, the USPTO has been open. So I don't know. Have you seen anything about that today?
Yes. I shouldn't have asked you. So Huda, our managing attorney, she sent this an image out to our leadership. The website, the homepage of USPTO says, at the present, the USPTO will remain open and fully operational until further notice, and under operating reserves from the prior year's fees collection.
Yeah. So, USPTO makes a lot of money for those listening at home.
What does that tell you? Now, it's comforting to know, but wait, that means they're overcharging. Interesting. Some for the coffers.
Yeah.
What if we never had a shutdown? What's going on?
Right.
So interesting. Yeah, we just saw that increase a few months back, maybe half a year ago.
Yeah, I think at least on the trademark side, it's in January. We
yeah.
Saw
Yep.
So yeah, I mean they've increased prices almost 50%.
Yep, that's right. Cool. All right, Matt. Well, I've got a couple of questions that came in. If you are out there, we have one. I see one live viewer. You're welcome to the show. If you have any questions, this is your time to pop in with Q&A. We'll get to you in our first 5 or 10 minutes, and then get to our guest soon after. So throw your question up there. This first one here is, talks about a lot of different intellectual property. And I'll put the question here. I'll pull it up. So what should you do after creating a game? Should you register it or license it or trademark register it? I have zero knowledge in this. How does IP attorney help? This person's based in Scotland, I guess. So we'll have to sort of say, well, if this were in the US, we could probably help.
Yep.
Do you know much about Scotland? And
I do not. I do not know much about the intellectual property system of the UK.
Right. Yeah.
But we've obviously represented lots of game developers over the years at Bold IP, and so I think between the two of us, we could probably manage to answer this question.
Yeah. Go ahead.
Yeah, no, I mean, from my perspective, I mean, as soon as you kind of have that idea for the game, like that's a great time to have an initial consultation with the attorney.
Yep.
Any intellectual property attorney is going to be able to look at what you're doing and give you some feedback on patent, trademark, and copyright. From my perspective, I'll focus on like the copyright and trademark side of things. If JD, you want to maybe talk about the patent side of a game, but you could file a copyright to protect the actual game itself and its components and how it works, or not how it works, but the instructions and that kind of thing. You could file it. It's probably not worth it, to be completely honest. We can file copyrights really whenever we need to and get them fairly easily. So that's not a huge priority from my perspective, but you would definitely want to do a trademark application. Most of these products that are going to be sold online. And that's the case, you're going to be selling on Amazon, and you really want a trademark registration if you're selling on Amazon these days. So talk to a trademark attorney, think about the copyright. Generally no copyright, but do look before you leap on the trademark side of things. And this would fall in class 28. It's the sporting goods category as well as the gaming category. Yeah.
Cool.
Nothing unusual here. Just, you should know that there's a lot of applications out there for games. So it's got to be a pretty clever name in order to register.
Okay.
That's my experience, at least.
Got it. All like the 3 and 4 letter words are almost all.
Yeah. Anything that you think is like pretty on the nose or like obvious or cute, right? Or, you're not going to be able to register that. It's going to have to be something a little bit more unique.
Got it. I think I would just add, if it's just you as an individual doing all the developing of the game, that keeps it a lot easier. I think maybe there's more complicated things if you have a team or you're hiring individuals that are creating and coming up with the gameplay, the rules, different types of design elements. You want to make sure that you as the owner, I assume you're the owner, have contractual agreements in place with each of those individuals, that the intellectual property, the artwork is all going to be owned by you. And on the patent side, not as often does it come up. I think quite rarely would we want to go for any type of design patent, unless you've really come up and spent a lot of effort on one particular element or feature and it's already been selling. Then there are ways you can kind of go back and try to, protect the elements. On utility patent side, gameplay and methods can be patentable, are eligible. Patentability is very challenging in terms of showing that it's really novel. And even beyond that it's not an obvious version. There's so many games you can imagine for centuries, plenty of games, lots of different references, and examiners would have a heyday looking at their online database all over the world of different types of games that have ever been played. So again, just show that this is the first type of game that's ever been done before, and that it would be a non-obvious version of the game. It's quite a challenge, but not impossible. So that's all I would say on the patent side.
Yep, good advice there. I really like that you threw in the work made for hire agreements. If you're paying artists to create content for the game itself, you need to make sure that they don't own any of that, right? That you, as the game developer, own that. Yeah, good advice, JD.
Thank you. All right, let's do one more. This is Reddit. It's a little detailed. I think it might be worthy of our attention here. Let's see. Oh, it's a long one. So there is a name for a business that I'm interested in using. I'm planning on getting a lawyer, good for you, and doing this thoroughly because it would be a huge pain to mess it up.
Yes.
Given that this is Reddit, I figured I'd ask if a trademark was never granted for someone who applied for it. Right? Over a year ago, the request was refused. And as of a few months ago, the request was deemed abandoned. Can others apply for it without it being considered dead?
Yes, you could. But, as a trademark attorney, I'm curious, why was that other trademark application abandoned? Was there an office action that, pointed out a huge issue with the name potentially, and they didn't respond to the office action, or they did respond to the office action, but were unsuccessful?
Right.
I'd be curious about that. I'd be curious if the trademark is from a different class of products or services in the first place. But yeah, certainly you would want to talk to an attorney about this, because if you're as a non-attorney potentially concerned about this, I think that's a great opportunity for you to go talk to an attorney.
And is that all public? Can your new attorney you're kind of gonna pick up this abandoned idea, this concept, and claim and move it forward?
I would be very worried about that, because if you're seeing an application that was abandoned, right? One, is that third party who abandoned the application still in business and still operating using that name? If so, they might still have rights in that trademark, not at the application, but they might have rights that are in common law or unregistered rights, both federally still, and potentially in the state in which they're operating, or the states in which they're operating.
Yep.
So yeah, I mean, just because something's dead or abandoned at the USPTO is not, permission essentially to go to market with something.
Got it. Yeah, interesting. That's a good question. And great
Really good question. Yeah.
Well, I think we're going to bring our guest on. We got Howell who's been waiting. Thank you for hanging in there, Howell, and welcome to the Bold Inventor.
Yeah, hello.
Hey, all right, great to have you. I'd like to have you introduce us kind of how this got started. Bold is a sponsor and participant in the National Innovation Challenge, and you were a winner. Would you kind of give us a little bit of a take on how you got into that NIC program and how it is that you end up winning?
My sister has always been interested in science, and she was the one that recommended me this this challenge, and we both participated in it. Yeah.
Love that. Big sister, younger sister?
Older sister.
Older sister. Okay, that's great. Good. Did she participate as well?
Yeah.
Oh, and did you beat her?
Yeah, I did.
Oh, nicely done, Howell. Okay.
Yeah, very, very nice. And Howell, you must be in middle school. You look like you were what, 7th grade?
Yeah, 7th grade.
Nailed it. There you go. My daughter's in 5th grade. Matt, you've got a big girl.
I got a 6th grader.
Okay.
And a 4th grader.
Yeah. All right. But my daughter is not yet inventing, but you, sir, are inventing, Howell. Okay. Tell us about what it is you've come up with. We're dying to know. I'm going to put you on a larger screen and walk us through what you've come up with.
So basically, I created a low-cost method for early screening of open angle glaucoma, which is a disease that causes damage in the optic nerve and loss of peripheral vision. So unlike traditional detection methods, like tonometry machines or physical eye exams, my system uses virtual reality, specifically the Google Cardboard and a smartphone inside to test the peripheral vision at home. So this invention basically has 3 parts. The first part is a VR-based grid test. It's a website that you can pull up on your phone, built using HTML, CSS, and JavaScript. So the user basically wears this VR headset, and the person would see a visual grid displayed across the field of vision, and then the user would point out which cells they can see.
Hold on just a second, Hal. Hold on. You're doing good. Now you put your phone in that cardboard box, right? And so that's how you're able to see images, right? There we go.
Yeah.
Okay. And let me back up a little bit more, because I don't understand glaucoma. So could you go back a couple of steps, help me understand? So it's a loss of periphery vision. Is that how?
Yeah.
This type of glaucoma?
Yeah.
I don't even know that. I mean, I know I've heard of it, and it's something I don't know if you can prevent it or not. But early detection sounds like it's a good thing. Is that right? Is it, if you just get it early, you can get it treated?
Yeah.
The idea.
You can't fix it completely, but you can stop it from blocking all your vision. Yeah.
Right. And one might not know that you're kind of losing periphery.
Yeah. Because it kind of spreads really slowly. So you wouldn't be able to tell if it's covering your vision.
Howell's nailing this glaucoma thing. So for those following along at home, right? Glaucoma is a disease essentially where you have damage to the optic nerve over time. Basically, the optic nerve is getting pressed on because you have excessive pressure buildup in the globe of your eyes. And so folks take, they use drops basically to lower the internal pressure of the eye to help reduce the strain and pressure on the optic nerve. One of the things that Howell's talking about with his device is that in medical, I know this because I used to be in medical and my wife owns a couple optical practices, but when folks have glaucoma, they're typically tracked on a quarterly basis to see if their vision is degrading. And we use this really expensive machine called a visual fields machine, typically, to help measure that. Really expensive, really big device. Sits in a corner of a room, takes up a lot of real estate. What Howell's talking about here is basically a novel implementation of a visual fields machine, which is fantastic. And I'm sure there's more to it than just the visual fields.
Oh, yeah.
So that helps a lot. Go ahead, Howell. Sorry. Yeah, no, please. That helps me a lot. Thank you, Matt.
Yeah.
Go ahead.
So the collected data from the website can be processed to generate a visual field map, as you said. And this map resembles the same thing, allowing a machine learning model to detect vision loss. So without a doctor. And
okay. So I put the goggles on. I'm just step by step. Okay. And I'm looking at maybe a vision, a field. How am I? Walk me through the test. Walk me through what happens.
So you would like put it on, and then there'd be a little like text on the screen, and it would say, "Oh, can you see like this square?" And then you'd reply like yes or no, and then you'd collect all that into like a big list.
Cool. And you're allowed to look around, or you can't move your head at all. It doesn't matter.
Look in the center. Like this
look in the center. Okay.
Yeah.
No cheating. Okay. Wow. And so you came up with the software as well?
Yeah.
Goodness. Tell me about that. Are you new to software development? Have you done that before?
Like I've always been interested in like coding, so I've had some experience doing something.
That's super impressive, Howell.
Wow. Okay. I mean, did you just dream this up in the shower? I mean, while you're at school, how did you?
Does grandpa have glaucoma? What's the story, right?
Yeah. So one of my close relatives actually have glaucoma, and like it wasn't that severe, but like it just inspired me to like help people who have like a similar case, I guess.
Yeah. Okay. Now, when you had to present this at the NIC, what kind of, did you get grilled with really tough questions? Was it scary? Tell me about the experience.
Yeah, I was definitely like really nervous, but the questions, like, as long as like you knew your project and like it's not that hard. Yeah.
Not that hard. Okay. The big question, of course, is does it work? Have you tested it on patients or maybe taken the next step to see if maybe it could be used in the clinic?
I haven't done that yet, but I use like data from like online from like those visual fields, and I compared it with my data, and the results were like pretty similar. So
pretty similar. Wow.
That's super cool, Howell. Like I think that augmented reality and virtual reality, like that technology, it's gonna be in clinics really soon. Like my wife just purchased a couple I guess Meta headsets for her offices because they're actually using virtual reality now to help create custom lenses for people based on their own personal like needs and vision. So yeah, I think your product, like your idea, like that's, I mean, if it can be implemented into that technology, like it's a no-brainer for a lot of people. Very cool.
Yeah. All right. So what's next for this? I know how you got a lot of other things, to make sure you keep your grades up in middle school and beyond. But are you going to pursue this in terms of taking it to market? Are you interested in securing intellectual property? Let's talk about that. Have you spoken about, patents or trademarks?
Yeah, I've spoken to like one of the lawyers at the patent office. Like,
cool.
Yeah, and they said it was like possible, I guess, to pursue like a patent.
Okay.
I think I want to improve my like design first, maybe before.
Right.
The first step. Yeah.
Well, that's good. Well, excellent. I mean, do you think this is, something that your parents would help with in terms of trying to get you, some resources to develop it? Or are you going to have to try to save your own money up and get a part-time job? Pretty young to do that.
My parents, like, I think, support me in a lot of ways.
That's fantastic. Yeah. Fantastic. Well, it's a great opportunity to be on the receiving end of that, of winning the NIC. It's a big deal. And I guess we can wrap up. If you could walk us through, your sort of look back, if you're going to do this again, and I don't know how long it took you to get to the finals, but would you have done anything differently as you came up with it or as you developed it at all?
I think like a really important thing I should have done was like do more research before just starting like building everything. Because like, you might miss out on like key information about thing you're trying to fix, and that's gonna cost like a lot of time. Yeah.
So you had to go through a lot of iterations and trials and errors.
So the more you learned about glaucoma, the more you had to go back and change things. Yeah. Cool. So so I guess it sounds like, for you, like if you had done maybe some more research into glaucoma initially, it could have helped you with developing the actual solution for the
Yeah.
test. That's a really great insight.
Absolutely.
Golden nugget there, JD.
Absolutely. Conduct some research and know the problem you're solving before just kind of developing a device. Well, I think you're on the right track. I think, while I'm not going to give, I don't want to give too much advice. One thing I do want to point out is that when you do publish or share an invention, a 1-year timer does start. And so that's a very important piece. And for anybody out there listening, is that there's a grace period of just 1 calendar year from if you publish or share or disclose your invention, you must file a patent application. If you don't, it's unfortunately going to get invalidated. Okay, unfortunately, there's a time bar. The reason for that is policy based, and the U.S. government doesn't want you to kind of keep your secrets. And to yourself, we want to all benefit from your knowledge, Hal, and all inventors out there. And so if you want to proceed with, perhaps achieving exclusivity for up to 20 years in the U.S. patent law system, those are the rules. So I wouldn't delay too long. Speak with your parents or anyone else that might be helping you, an adult, to work with either on your own or with counsel. I do recommend working with an attorney to at least get what's called a provisional patent application filed. So you'll be pending and have the chance to develop it a bit more, as you said, work on the design and get it to a point where you're ready to say, hey, this is it. I could take this to, a physician, an optometrist, an ophthalmologist, whatever you might need to see. Sound good?
Yeah.
Super cool, Hal. And I was just thinking more about this too. Maybe I don't know what your use case for this is, but this would be something for grandma and grandpa to use at home, to check in instead of maybe going to the clinic every 3 months. We could do this at home. I really like that a lot. Congratulations on your success. It's a really cool idea, and I think it bodes well for the rest of your middle school career.
Yeah.
Absolutely. Howell, thanks again for joining us. Have a great day.
Thank you. Bye.
Bye-bye.
What a cool kid.
Awesome to have him. So cool. Big opportunity.
No big deal. Just talking to two, old attorneys, 12 years old. No big deal.
He seemed pretty confident, and he's really gone through that process. Pretty neat. Yeah, Julie Shively and the others over at the NIC have been just very gracious to have us be a part of that. They've been doing it now for a number of years, and I think they're getting, it's a worldwide innovation challenge. So next year will kick off, I think, in the spring, and they'll go all the way through September, and that's when they have their finale. Cool. Well, Matt, that's all we had for the show, unless we had anything else you wanted to hit on or talk about.
Back to work.
All right, sir. Well, thanks again. And for Matt, myself, and those here at Bold, wishing you a great day. Go big, go bold.